Question number 3, Honourable Shane Jones.
Point of order, Mr Speaker.
Point of order, Honourable Shane Jones.
Sir, I seek your forbearance. Last week I tabled a letter to the Chairman of the Commerce Commission, and after some confusion it was accepted, sir, by the House that the letter could be tabled. Sir, later on in the afternoon, the Clerk of the House, as is her prerogative, sir, identified that the letter could not be released by her for fear of becoming embroiled in defamation proceedings. Sir, I seek some direction from you, given that our ability to function effectively as parliamentarians, traceable back to the Bill of Rights 1688, incorporated into British Statutory Law 1689, don't want to overstate the fact, sir, but it's a key feature of being a parliamentarian. Final point I'd say, sir, is that whilst there is the prospect of defamation proceedings in the mind of the clerk, there is also, sir, the ability of parliamentarians to fulfil their obligations on behalf of the broader public interest. Now, sir, I've taken the time to study earlier pronouncements on the matter, and indeed, not unlike Jerry Brownlee, have come armed with Erskine May. But, sir, the most important thing is I feel this has a chilling effect on the ability of parliamentarians to speak truth in the face of adversity, and if we don't back down to this type of threatening behaviour, sir, I fear it will be no different than the mongrel mob mayhem on Manchester Street.
Honourable Jerry Brownlee, speaking to the point of order.
I think the Honourable Shane Jones raises a very interesting point that is probably worth some discussion away from the floor of the House today. The point I think he makes is that if a member is tabling something in evidence of a comment made under the protection of the House, for the rest of the House to be able to verify the reason for the utterance, but that apparently cannot be tabled because it might affect or might lead to officers of the Parliament, in fact, being pursued through the courts, then that is an unreasonable block on the freedoms that Parliament claims and that you, sir, on our behalf, claim of the Crown. So I would suggest that this is a matter that's probably not going to be dealt with now, but does need some discussion fairly urgently, perhaps by the Standing Orders Committee in the next very short while.
Can I refer, this is an important issue and both members raised this point because it has long-term ramifications. Can I refer members to Speaker Ruling 1461? And there members will note that as Speaker Wilson ruled in 2007, the general presumption is that documents tabled by leave will be made available on request, the House having accepted them. But it needs to be clearly understood that it is only where a document is published under the authority of the House that it is protected by parliamentary privilege in respect of any subsequent publication. The tabling of a document does not mean that the House has ordered or authorised the publication of that document. It simply allows for the information contained in the document to be conveyed to members of the House. Publication of the document to persons outside the House is done at the risk of the person who publishes it. In that respect, published means delivering, showing or disclosing it to any other person. Where there is risk of legal liability arising from publication, the clerk will permit members to have access to the copy provided to her, but will not disclose it to anyone else. All requests are referred to the member who tabled the document. While this is not a regular occurrence, the clerk does have to be mindful of possible legal risk. The clerk has informed me of her decision not to publicly release the document. The matter is therefore one where the member must take responsibility for the release of the document. It will be published by the clerk only if the House were to order or authorise its publication. A point of order, Right Honourable Winston Peters.
Speaker, I so move that the House give approval for the publication.
Well, leave is sought now for a paper A letter that was tabled here last Thursday, which at this stage has not been published. Yes, I'm just making sure that members understand. The leave is sought first for this motion to be moved. Is there any objection to that leave? There is not. Right Honourable Winston Peters.
Speaker, I move that the House give permission for the Clerk of the House to publish to the media and outside interests. Pardon?
Yes. Can I just...
well, I'll just amend it slightly. I move that the House direct the Clerk of the House to distribute the document tabled in the name of Shane Jones, about which this discussion is.
The question is that the motion be agreed to. Those of that opinion will say aye. Are you just speaking before I put the motion? Right, the Honourable Jerry Brownlee.
Mr. Speaker, it's more of a point of order, in fact. So, no disrespect to Mr. Peters. I know what he's trying to achieve, but I don't think the Parliament directs the clerk. I think what happens is that Parliament authorises the publication, and I think that would be a far better set of words in the motion. So I don't want to amend the motion. The member might like to consider putting it again. It's slightly semantic.
It is.
Rather than us directing, Parliament would be choosing to authorise publication.
Order. This is a very important matter that this House gets right, so I'm prepared to accept the Honourable Trevor Mallard.
And Mr. Speaker, the reason that I gave some advice to the member moving the motion to make it clear that it was a direction, because an authorisation would in fact still leave the clerk with a discretion whether or not to make it available, and my objective in suggesting that the word direct be used is to make sure that the Clerk of the House is not herself subject to legal action.
Order. Can I've just sought some advice from the clerk, and the following points before I put the motion may be relevant. The allegations contained in the letter are potentially actionable and run the risk of being seen to, in effect, repeat statements made in the House by the member last Wednesday. This does have a chilling effect. Such a matter might usefully be considered by the Privileges Committee. However, the motion, I think now modified, is that the House order the publication of the document. Speaking to the point of order, Honourable
Sir, I want you to be utterly explicit that in passing this motion, the doctrine of absolute privilege will now cover that letter.
And my understanding is if the House is prepared to accept the motion, then that is indeed the case. Speaking to the point of order.
Mr. Speaker, the wording that I wish is that this House, I move a motion that this House direct the Clerk of the House to publish the document in question, not authorise it, to direct that she do so.
So doesn't that then fit with the wording that I put here? The House order the publication of the document. This order. Speaking to the point of order, and then I think we've had enough discussion. The House knows the seriousness of the situation. I'll put the motion, but before that, I'll hear from the Honourable John Banks.
Mr. Speaker, a point of clarification. If we follow this track to its conclusion, does this mean that this House is open to legal redress from parties outside the House, and is not the simple remedy for Mr. Jones is to take the document out to the steps of Parliament and distribute it to the press if that's what he believes?
Order. The first part of the question asked by the member, if Parliament so moves today, then it itself is protected by parliamentary question. So the motion is that the House order the publication of the document. Those of that opinion will say aye. To the contrary, no. The ayes have it. It will be published. Question number 3, the Honourable Shane Jones.
Mr. Speaker, to the Minister of Commerce, was he made aware of any concerns regarding the behaviour of supermarkets towards suppliers prior to February the 12th, 2014?
Mr. Speaker.
Honourable Craig Foss.
Thank you, Mr. Speaker. Yes, but I was not aware of the specific behaviours raised by that member alleging blackmail, extortion and retrospective payments in the New Zealand supermarket sector.
Supplementary question, Honourable Shane Jones.
Is he concerned that despite anonymity in this case in terms of an investigation by the Commerce Commission, New Zealand-based suppliers are fearful that what they tell the regulator could be passed on to the Australian Woolworths supermarket chain and they could end up blacklisted off Australian supermarket shelves?
Mr Speaker.
Honourable Craig Foss.
Mr Speaker, I understand the Commerce Commission itself actually has issued a press release reinforcing the confidential nature of any complaint. Mr Speaker, the Commerce Commission, as part of their normal business, are dealing with sensitive affairs at all times and have, as in that press release, treat matters in confidence and very sensitively.
Speaker.
Supplementary question, Honourable Shane Jones.
Is the Minister prepared to release to the public what correspondence he has received in respect of this egregious behaviour by Australian-based supermarkets in the world of New Zealand commerce?
Mr Speaker.
Honourable Craig Foss.
Mr Speaker, as I noted in the answer to the primary, the specific allegations of blackmail that the member made, of extortion that the member made, and retrospective payments, Mr Speaker, I am not aware of receiving any information along those lines.
Point of order, Honourable Shane Jones.
Sir, I did not specify the language used in his response. I invited him to declare to the House that he would release correspondence he has received in respect of egregious supermarket behaviour.
And as I understood the answer, the Minister said he may want to elaborate that he was unaware of any correspondence to that effect. Does the Minister want to elaborate?
Correspondence I've had since these allegations were raised, I will be treating in confidence and sending those to the Commerce Commission.
Supplementary question, Honourable Shane Jones.
Will the Minister support my call to broaden the terms of the Commerce Commission inquiry into excess power wielded by the supermarkets, especially Australian, over suppliers and customers?
Mr Speaker, this issue has been around for quite some time in regard to the supermarket sector. I note the former Minister of Commerce, the Honourable Leanne Dalziel, put her mind to this matter way back in 2008. It is ongoing, Mr Speaker. I think it's right and appropriate that we wait for the formal, proper process of the Commerce Commission to deliver its findings.
Speaker.
There's a supplementary question, Honourable Shane Jones.
Why is it his first instinct to back the Aussie-owned supermarket Countdown rather than to back New Zealand businesses and workers? And what telephone lobbying has he received in that end?
Mr Speaker.
Honourable Craig Foss.
I resent that accusation, Mr Speaker. I am not the one that made allegations of blackmail. If the member has allegations of blackmail, that member should go to the police. I have faith in the processes of this government, of this parliament, that have been enduring for quite some time, Mr Speaker. I back competition in New Zealand and under the Commerce Act, which allows the best prices for New Zealand consumers to be found over time.
Question number 4, Dr. Russell Norman.
Thank you, Mr Speaker. My question